Did you know in California there's a 6 month rule in divorce cases? Did you know before that you cannot finalize your divorce case in California before 6 months? In California, there is a mandatory waiting period. But what does it mean in reality? You can file the case, you can reach an agreement, and you can even submit the judgment. However, you cannot finalize your divorce case before 6 months pass. Does it apply to all cases? Yes, it applies to all divorce cases. Even contested, uncontested, stipulated judgment, joint petitions, and default cases. Although both spouses agree on all the terms, there is a mandatory waiting period of 6 months. And this is a very important rule in California because we do have many clients that they're asking for instance, they say they agree on everything and they're asking whether it's feasible for them to get divorced in, let's say, 1 month, maybe even in a few weeks. And we say no, because it doesn't work like that. Although you agree on everything, we can draft a perfect marital settlement agreement for you. We can submit everything to the court and we can submit the judgment forms. However, in order to get the finalization, we need to wait for at least 6 months. And this is not an exact 6 months period. This is the minimum time frame that we need to wait in order to get the judgment degree. Some people think that they can wait this waiting period. There is a way to shorten it. However, this is a very common misconception. Judges do not have any discretion to shorten that time or wait that time. However, for legal separation decisions, there is no such minimum waiting time period. So for a separation case, you can get the decision immediately. So remember and be careful. No matter how simple your divorce is, California law requires that 6 months waiting period. Timing matters and strategy matters more.
You are